political leaders place pressure on prosecutors to file charges against their political enemies. What are the implications if prosecution decisions are based on politics, not the law?
I think it weakens the rule of law in our country because it weakens the mechanism for us to prosecute, among other things, corruption. When there is political prosecutions targeting people because they're enemies of the president, the department loses credibility.
This may look like another partisan exchange in Congress, but it's actually a stress test for the justice system itself. What's really being tested here is whether prosecutors can operate independently when political pressure and public narratives collide. This raises broader questions about how accountability survives in an era where legal institutions are routinely challenged for political gain. In this video, we'll break down how this hearing exposes the fragile line between law enforcement and political influence, and why that line matters for the future of democratic credibility.
Gentleman from New York is recognized.
Thank you, Mr. Chairman. Mr. Smith, over the past few years, Republicans have waged constant attacks on you. Donald Trump has said you are totally compromised, a political hitman, a left-wing radical, a criminal, a fully weaponized monster, and that you should be considered mentally deranged and thrown out of the country. Just this week, he called you a sick bastard. Unfortunately, the rules of decorum prevent me from saying what I think of Donald Trump. But he is not the only one to launch attacks against you. Chairman Jordan has accused you of abusive surveillance and accused you and your team of partisan and politically motivated prosecutions. Despite the mountain of evidence that you laid out in the special counsel's report and in your court filings, President Trump's supporters are convinced that the only reason your team tried to hold him accountable is because you have a vendetta against him. I want to address these allegations today. You have had a long and distinguished career with the Justice Department, including serving as the chief of DOJ's Public Integrity Section for 5 years. While leading the Public Integrity Section, you led investigations and prosecution of public figures and political leaders from both parties, Republicans and Democrats. Can you give us a couple of examples?
Sorry about that. During my time as the chief of public integrity, I investigated cases involving both Republicans and Democrats. The standard in all of those cases was the same: follow the facts and the law. Didn't matter what party you were in, it mattered the facts of the case. In doing that, there were cases I brought against Democrats and cases I brought against Republicans. There were also cases that I investigated and did not bring against Democrats and Republicans. Party affiliation played no role in my investigations. I can think of multiple cases of prominent members of Congress that we investigated who were Republicans who, upon reviewing the law and the facts, I decided not to go forward in those cases. And the same can be said with people on the Democratic side. I've always tried to follow the facts and the law in my career.
When it comes to deciding whether to pursue a criminal prosecution of an individual, what factors do you consider?
The primary factors are the facts and the law. As a federal prosecutor, in making a prosecutorial decision, you're guided by the federal principles of prosecution, which guide one not only to look at the facts and the law, but the federal interests. And that is exactly what we did in this case, as set forth in my final report.
Does partisan politics play a role in your decision whether or not to prosecute someone?
None.
To be clear, did partisan politics play a role in your decision to charge Donald Trump?
It did not.
What does it do to the justice system if political leaders place pressure on prosecutors to file charges against their political enemies? What are the implications if prosecution decisions are based on politics, not the law?
I think it weakens the rule of law in our country because it weakens the mechanism for us to prosecute, among other things, corruption. When there is political prosecutions targeting people because they're enemies of the president, the department loses credibility and it can't do its job in all sorts of cases.
According to your deposition before this committee, it sounds like your problem was not determining if you had enough evidence to charge Donald Trump, but rather that you might have had too much evidence and struggled to determine how to present the clear narrative to a jury. How would you characterize the evidence against Mr. Trump about inciting an insurrection against the laws of this country? Did you have too much?
Well, with respect to presenting the case that we charged, one of the central challenges was trying to present that in a concise way because we did have so many witnesses. Some of the most powerful witnesses were witnesses who, in fact, were fellow Republicans who had voted for Donald Trump, who had campaigned for him, and who wanted him to win the election. These included state officials, people who worked on his campaign, and advisors. I will say, however, with respect to the charge of insurrection, we did not charge that. As I set forth in my report, Well, I believe that there is, courts have found that that was an insurrection and that there's a reasonable interpretation, a reasonable prosecutor could interpret the evidence to support that charge. I chose not to do that, looking at the facts in the law. I thought the charges we brought were appropriate, given the evidence that we had.
Thank you, Mr. Smith, for your decades-long public service and for working tirelessly to uphold the rule of law. Those who attack and smear you and your team in order to protect Donald Trump should be ashamed of themselves. I yield.
What we just witnessed was not a casual exchange or a passing moment in a routine hearing. It was a direct confrontation between accusation and principle. A sitting member of Congress laid out, in stark terms, the barrage of personal attacks directed at a federal prosecutor and then asked a simple, unsettling question: when everything is stripped away, the insults, the slogans, the political theater, what actually guides justice in this country? Jack Smith's answer was calm, restrained, and unwavering. The facts, the law, nothing else. That moment matters more than it may appear at first glance. Because this was not merely a defense of one man's career, it was a defense of the idea that justice can still exist separate from power, loyalty, or fear. When Smith stated that party affiliation played no role in his decisions, not when he investigated, not when he charged, and not when he declined to charge, he wasn't just responding to critics. He was drawing a line between a system governed by evidence and one governed by allegiance. For years now, Americans have been told that accountability itself is partisan, that enforcing the law against the powerful must automatically be driven by politics, that if someone is investigated, it must be because of who they are, not what they did. And in this hearing, that argument was placed squarely under the light. Smith reminded the committee and the country that his record includes investigations across the political spectrum, including cases where evidence did not justify charges. Those decisions, he emphasized, were made quietly, without applause, without headlines, and without regard to who might benefit politically. This is the uncomfortable truth many would rather avoid. A justice system that only prosecutes one side is illegitimate. But so is a system that refuses to prosecute anyone with influence. The rule of law does not survive by protecting reputations. It survives by applying the same standard to everyone, even when it is unpopular, even when it invites attacks, even when it places immense pressure on those tasked with carrying it out. When Smith explained that political pressure on prosecutors weakens the entire system, he wasn't speaking in abstract terms. He was describing a real danger, one where legal decisions become tools and prosecutors become targets. In such a system, credibility collapses, not all at once, but slowly, case by case, decision by decision, until the public no longer believes that justice is blind, only selective. Perhaps the most revealing moment came when the conversation turned to evidence. Not whether there was enough of it, but whether there was too much. Smith described a challenge rarely acknowledged in public discourse: the difficulty of presenting a complex, fact-heavy case in a way a jury can fully absorb. He spoke of witnesses who were not political opponents, but allies. People who had supported, voted for, and worked alongside the individual under investigation. That detail alone undercuts the narrative of a purely partisan effort. Evidence does not choose sides. It exists or it doesn't. And yet, even then, Smith explained that he declined to pursue certain charges, despite believing that a reasonable legal argument could be made. Why? Because prosecutors are not supposed to pursue every possible theory. They are supposed to pursue appropriate ones grounded in law, precedent, and the likelihood of justice being served. That discretion is not weakness. It is restraint. And restraint is one of the last remaining safeguards against a justice system driven by spectacle instead of substance. This hearing exposed a deeper conflict playing out across the country. A struggle between two visions of power, one where institutions exist to protect individuals no matter their conduct, and another where institutions exist to protect principles, even when doing so is costly. When lawmakers use their platforms to discredit prosecutors rather than debate evidence, they are not defending liberty. They are eroding trust. The language used against Smith was designed to intimidate, to delegitimize, and to distract. But intimidation only works if silence follows. In this case, it didn't. What followed instead was a clear articulation of how justice is supposed to function, not in theory, but in practice. Follow the facts, apply the law, accept the consequences. This is not about one investigation. It is about whether Americans still believe that no one is above the law and no one is beneath its protection. It is about whether accountability is something we demand only from our opponents or something we accept for ourselves. A system cannot survive if its legitimacy depends on who wins an election. History shows that democracies do not collapse in a single dramatic moment. They weaken when standards are selectively enforced, when truth becomes optional, when loyalty replaces law, and when those tasked with upholding justice are punished simply for doing their jobs. What we saw in this hearing was a rare moment of clarity, a reminder that the rule of law is not self-executing. It relies on individuals willing to withstand pressure, endure criticism, and remain grounded in principle. That is not partisan. That is foundational. The question now is not what Jack Smith believes. He answered that clearly. The question is what the rest of us are willing to defend, because a justice system only functions as long as the public demands it do so. If accountability becomes negotiable, then fairness becomes fictional. This moment will not be remembered for the insults hurled, but for the standards reaffirmed. And whether those standards endure depends on what comes next. If you believe transparency matters, if you believe accountability matters, if you believe the rule of law matters, support our work to expose the truth. Subscribe to Liberty Report USA.